Hello, everyone. Good afternoon.
Hello.
Good morning if you're joining us from elsewhere. And a very warm welcome to the next of our TMA Europe Now webinar sessions. Before we get stuck in, the obligatory disclaimer, just give you a quick look through. We are recording this session and it will be made available after the event for registered attendees initially. We have another webinar tomorrow. If you are not registered and would like to join us, EACTP are hosting the next of their mastermind sessions, this one focusing around leadership in turnaround and defining purpose, handling transition, etc. Please do register. It will be a fantastic session, more soft skill focused. A quick overview of what we have coming up in the TMA community across Europe and into the US. So our Turkish colleagues are hosting their annual conference next week. Maybe a little late on travel, but do join them. And please save the date for the DACH region event in early January. TMA Europe also in December, we will be going live shortly with the next of the TMA live programs, starting with a webinar. And this year's focus is on the brewing and beverage industry. So please do join us. You know the housekeeping, we'll stay on mute for now, but please do put your questions to the panel in the chat box, and Anya, our moderator, will pick those up as we go through. We'll also be heading into breakout sessions after, so please do stay with us to continue that conversation. And with that, I will hand over to Anna.
Hi all, welcome to our webinar. I'm Anna Nolan, the chair of TMA Now Europe. Our committee is running a series of webinars for members of TMA. It goes without saying that guests and friends of TMA are also welcome to join us. I'd like to take this opportunity to encourage you to send me your feedback by email. And if your organization would like to sponsor one of our webinars, or if there is a particular cross-border topic that you find interesting, our committee will consider it, and the next webinar might be the one that covers it. Soon, I will be handing over to our moderator, Anya Groze-Gagnier, who is a partner with BMH in France. With more than 25 years of experience, Anya has managed a landmark insolvency and restructuring cases in various sectors of the economy in France, and has always had a soft spot for cross-border insolvency cases. She assists many lenders, investment funds, and shareholders in French pre-insolvency and insolvency proceedings. Her recent cases include Novasco, Ascometal, Orpea, and Atos, as well as landmark real estate pre-insolvency restructurings. Anya was recently co-chair of the insolvency section of the IBA. She is chair of TMA Network of Women in France.
Thank you very much, Anya. Hello, everybody. I'm very happy to be moderator of today's webinar. First of all, I would like to present our speakers from 3 jurisdictions. We have Anna Nolan from the UK. Anna is counsel in Alston & Bird's London office, where she works on contentious and non-contentious matters in England and internationally. She works on high-stakes matters for debtors, creditors, trustees, investors, and insolvency practitioners. Anna helps her clients finding consensual solutions, although she also advises on schemes of arrangement, restructuring plans, CVAs, and administrations. Recently, she represented her clients in connection with the bankruptcy of Northvolt AB, Chapter 11 of Meyer Burger, the emergence of Scandinavian Airlines from Chapter 11, and Synchrion's financial restructuring implemented by English scheme of arrangement. Welcome, Anna. Then we have Christine Boris from Germany. Christine is partner at Jones Day in Munich. Christine has an experience of 21 years in insolvency and restructuring. She started working at an insolvency administrator firm in 2004, went 2 years into university studies, and joined then Hugen Lovells and later Jones Day. Christine does general restructuring and insolvency work for debtors, creditors, and shareholders. Her recent track record includes the withdrawal of insolvency filing for Chinese shareholder in German insolvency of Sora spinning business in combination with a 300 million asset deal to Swiss-based Rita. The representation of Federal Republic of Germany in the insolvency of Galeria Kaufhof, and the representation of the Bogner family in the sale of 60% of Bogner, who had been put into a double-sided trust agreement to Katjes as new majority shareholder. Then from France, we have Juliette Bourg, who is partner at DWF in Paris. Juliette has specialized in restructuring since 2013 and has acquired solid experience in pre-insolvency and insolvency proceedings and the handling of complex turnaround situations in a wide range of industries. Juliette assists lenders, investment funds, shareholders, debtors, purchasers, and creditors in both amicable and judicial settings. She also defends the interest of executives when their liability is at stake. Her most recent cases include the advising of Paris 2024 Olympic Games Committee in the rehabilitation proceedings of its key supplier Le Coq Sportif, advising French credit institutions that granted a loan in the aircraft industry, in particular on issues related to the security interest granted within a pre-insolvency scheme, and advising a tech company in the context of a conciliation and reorganization proceeding of a company developing software designed for online merchants operating on Amazon and Walmart. So this is quite impressive. Welcome to Christine, Juliette, and Anna. So today, with our restructuring specialist of the 3 jurisdictions, Germany, UK, and France, we will be exploring the evolving landscape of cross-border restructurings, in particular with respect to recognition issues. Indeed, in the European Union, we are very happy with the EIR regulation, the 10-year-old recast, according to which recognition of insolvency judgments handed down by courts of member states is automatic and immediate. This is very comfortable, and we took it for granted. Under the recast, there are no French court decisions undermining automatic recognition, as the French Supreme Court puts high standards for public policy exceptions able to undermine the automatic recognition effect of the EIR. Now, Brexit makes it all different, and we have to reconsider a lot of issues. So after this first part, we will be looking to the US and give you insights and practical challenges faced by European practitioners with Chapter 15. And again, we return to the UK in the second part of the session, where Anna will illustrate some innovative UK restructuring plans. In the third part of the session, we will go back to the European Union and report shortly from the very last developments in the discussions around Insolvency 3. So this is a very ambitious plan for the present session, and let's delve directly into the first part. The first part is the recognition of insolvency-related judgments involving the UK. In July 2025, the Frankfurt Regional Court refused the recognition of the UK Part 26A restructuring plan for aggregate. This judgment raises practical implications for European cross-border restructurings, especially those that seek to use a UK restructuring plan to compromise German law-governed debt, the obligations of German obligors, or involve assets in Germany. Christine, could you please explain why the Frankfurt Court held that aggregate UK restructuring plan did not qualify for recognition in Germany?
Thank you, Anja. Also, thank you for the introduction. I think the very easy and straightforward answer is that the court was still angry that the UK left the European Union, and there's some disappointment that the UK manages to get the restructuring plan in so many proceedings while the STARC hasn't been that popular yet. So I think that is the unofficial answer. So, but to give a more precise one, the decision of the Frankfurt Court was based, or was preluded by a very controversial discussion under German law, how restructuring plans under UK law can be or cannot be recognized under German law. And this to give you some background how we even got to that case. This aggregate company is a company that was established under Luxembourg law and operated a large-scale real estate project in Berlin. It had, inter alia, a German law-governed senior facility agreement, whose repayment was claimed in front of the Frankfurt Court. In the Frankfurt Court, the company had initiated a Part 26A proceeding in the UK in 2023, and that restructuring plan was accepted by the creditors, which there was a large majority of, I think, 97%. So basically everyone except our German creditors, and was confirmed by the High Court in the UK. And the High Court found and looked at it and found that from a UK perspective, they found it likely that the plan would be recognized under German law. So the UK High Court did look at the German discussion on how to or not to recognize proceedings from the UK. So what happened? From German perspective, since the UK left the EU insolvency regulation is no longer applicable. So UK has become a third-party state, and German international insolvency law applies as like first instance to look to on the question on whether or not to recognize a restructuring plan. German international law, the relevant provision states that foreign proceedings are to be recognized under three conditions. First of all, the respective proceeding must be an insolvency proceeding. Second of all, the opening courts must have jurisdiction under German law. And third of all, we cannot have an ordre public violation. Here, the court got hung up on the first criteria. The question, is the UK restructuring plan proceeding, the Part 26A proceeding, an insolvency proceeding in the sense of German international insolvency law? And the court said, no, it's not. It based that decision on a high court, a German high court decision from 2012. In 2012, the German high court had decided to qualify as a German insolvency proceeding, you basically have two objectives. The first objective is that the debtor that is put into those proceedings needs to be insolvent and cannot be a healthy debtor. The second criteria must be a collective proceeding applying to all creditors of the debtor. And there's the decision from 2012. It was said, well, it was about a scheme of arrangement, and scheme of arrangement had a solvent debtor, so it didn't qualify as insolvency proceedings. Here now was the restructuring plan. They didn't consider the question if insolvency or not insolvency, but they said, well, the restructuring plan only applies to some of the creditors and not all of the creditors, and therefore it's not collectively referring to that old decision from 2012. We're not going to recognize based on German international insolvency law. that is interesting because in other decisions, Chapter 11 had been recognized as an insolvency proceeding under German law, where you could ask the question, well, does Chapter 11 always apply to all creditors, or can't you choose in there? And also, this High Court decision from 2012 was prior to the introduction of the whole restructuring regime under the European insolvency regulations. So in 2012, there was no START, there were no, like this whole idea of having restructuring proceedings that only apply to part of the creditors didn't exist across Europe. So one can very well argue that this High Court decision from 2012 is outdated and should not have been applied in the consideration whether or not to recognize the British proceeding. In German discussion, there are like two further arms discussed on how to recognize, in particular, UK proceedings. The first one was the German international insolvency law, where the court said no. The second one is the question, can we recognize a UK restructuring plan as a foreign judgment under a civil procedure law? Basically saying it's like a judgment, and therefore we can recognize it. That has a number of requirements. And the last requirement for the recognition as foreign judgment is that there's reciprocity. So in the German discussion, it's always the question, rule of Gibbs coming up. I think, Anna, you're going to support your rule of Gibbs, and whether that would hinder the recognition as a foreign judgment. However, the Frankfurt Court, since it was only a conditional proceeding or limited proceeding, like some specialty under the procedural law, said for procedural reasons, we essentially cannot make a hearing on that question, and this is being disregarded by procedural law. So they found a way to not answer the question whether the reciprocity rule of Gibbs would hinder the recognition or not, and just said we cannot do it in those proceedings here. So we still don't have an answer for that. And then the third block that is being discussed after international insolvency law, recognition as foreign judgment. Third block is recognition under public law and treaties. Is there like a treaty from before European Union times which we can use to recognize this? And there the court basically said in two sentences, no, those treaties have been replaced by EU regulations and they have not come back into force. However, the court didn't really look at the details of the discussions. There are further treaties being discussed that could be used. So all in all, it is a very high level decision. It is first instance and it is this Urkundsprozess where it's not a full process. So this process is going to put in front of the court again, and there might be appeals. So it's not the final decision that has been made, but of course it's an indication and it's a decision. It's a decision out there.
So thank you very much, Christine. Very highly interesting. It was somehow very shocking, nevertheless, even though it was a sort of provisional decision. And Juliette, how would a French judge consider this? What would be his position with respect to a UK restructuring plan? What would he say?
Many thanks, Anya. From a French perspective, so since 1st January 2021, the EU regulation is no longer applicable, as Christine outlined. As such, from a French perspective, we cannot longer use this EU regulation regarding UK decision, and we have to refer to the exequatur, which is in France the possibility to get enforcement of foreign states not being in the EU to get some effects within French jurisdiction. And as such, there is three criteria for exequatur. The first one is that the foreign court is competent, i.e. French jurisdiction is not competent, has not exclusive jurisdiction. So as such, we will talk about that after with the committee. The second one is the absence of fraud. to get an exequatur, which is one of the criteria that is very difficult to prove, so easy to collect and require. And the last one is to be sure that this decision from a third party states is with any lack and absence of incompatibility with the public policy, public order. So these are the three criteria that a French judge will look at to apply or not a UK decision effect within France. We could think that for the first one, regarding the jurisdiction of foreign courts, the regularity of the commis transferred by aggregate to the UK should be outlined. At least some question may raised about that. Because if the transfer was not justified by, under French requirements, some operational management activity in the UK or direction, then the commis criteria might be challenged. So then we could argue for some forum shopping to deny effects of a UK decision within French. The second criteria I was referring about was the fraud, which was not consistent in that case. And I guess that a judge will not characterize any fraud. And the last one is so the absence of conflicts with public policy. And this is a quite delicate question because in France, since the transposition of the 2021 directive implementing a cross-class crackdown application within France, it is possible to rid off some debts even more than reinstall, which was both the case in aggregates. So these criteria of any conflict with public policy would be really looked at from a French judge from the cross-class crackdown application, which is quite complex in France. The legislation is very documented, and now we have some experience in the last years. But I guess that since cross-class crackdown is applicable, the decisions so far we made in the amount of the aggregate case were qualified by French judge as some effective safeguard or rehabilitation plan with cross-class crackdown application. The French judge might qualify it. So the first point of exequatur would be the first one, maybe the commis, that would be the more at stake or at least debated.
Thank you very much. And now vice versa, what issues are there in the UK regarding the recognition of the French restructuring plan from a French perspective? I'm thinking about the Lion Air case. Juliette, what do you think?
Yeah, this Lion Air case was one of the first decisions since Brexit that UK recognized effect of a French decision. So this one was a very interesting one for French practitioner. And for the recall, the restructuring of Ciel Voyage Group, which is a French manager of aircrafts of the Indonesian Lion Air Group, was a case where in the commercial aviation sector, most of the aircraft and fleets was not owned by the airline, but by lesser owner and partially managed by intermediary companies. And due to the COVID situation and the market at that time, we were talking about 2021, the activity of the airlines was affected by the health crisis and the sudden collapse in the traffic. So the company was not able anymore to meet, to serve the debt and meet all the charge, particularly with the lessor. And this is why some negotiation started with 5 companies of Ciel Voyage Group within safeguards and rehabilitation proceeding open in June 2021. So after Brexit, but before implementation in France of the EU directive of cross-class crackdown application. And the cross-border implication of that case were that the companies and their judicial administrators applied and obtained recognition in the UK of the French insolvency proceedings. So just for you to know, we were with public proceeding in France, negotiating bilateral or third parties agreements at the same time. And the English courts could have been designated as soon as a significant part of the French company debt was governed by English law, so applying the GIPS rule in the UK. And in the UK, recognition of judgments is based on the UNCITRAL model law on cross-border insolvency, and the recognition of French insolvency proceedings were therefore sought on the basis of the CBIRE, so cross-border insolvency regulation, where British regulation transposed the UNCITRAL model law into English law. And so regarding, unlike an exequatur mechanism that we talked about on the vice versa situation, then the CBIR implies the application of English law on the stay of proceedings. And what happened for our case? The Ciel Voyage Lion case was having this effect of recognition if the contractual workout agreements that were found from the UK recognition implied that the French jurisdiction were no longer, open, and that the difficulties ended from a French perspective. And this is how it ended in that case, because it's ad hoc contracts that were signed simultaneously with each lessor, collectively the lessor, so that the French commercial courts could acknowledge the restructuring and workouts and handed French judicial and public proceedings. So this was first decision after Brexit was interesting for that point, for the mutual recognition as part of as a global workout agreements, where the difficulties were dealt and the company struggled all this activity and restructure with ad hoc proceeding, even though judicial French insolvency proceeding were firstly opened.
Mm-hmm. Thank you very much. This leads us to the UK, Anna. What is your view on the recognition of the French restructuring plan in the UK, and coming to the everlasting rule in GIPS, which some considers to be somewhat hypocritical and outdated, while others seem to seek its protection? Why are the views here so divided?
Yeah, so following on what Christine and Juliette said, I absolutely agree that the life of a restructuring professional who lives in the UK and tries to obtain recognition in Europe is much more complicated than before Brexit. And as Juliette said, recognition of a French restructuring plan is no longer automatic, and a French representative would need to seek recognition under the model law that was adopted in the UK through the cross-border insolvency regulations 2006. But regarding recognition of a French restructuring plan, the main question here is, what is the law governing the contract? And by extension, the debt obligations that have been amended or extinguished by the French restructuring plan. So in the UK, we have that rule in GIPS, and the rule stipulates that the applicable law of a contract governs, amongst other things, its variation and discharge. So I will just read what one of the key UK authorities exactly said about that rule. A discharge from any debt or liability under the bankruptcy law of a foreign country outside the UK is a discharge therefrom in England if, and only if, it is a discharge under the law applicable to the contract. Interestingly, it applies equally regardless of the applicable law. And this means that English law would recognize the effect of a French insolvency or restructuring proceedings in relation to French debt. But if it's English debt, English law would not recognize the effect of a French insolvency or restructuring proceeding in relation to English debt. And it may be necessary to run a parallel UK process to provide certainty for interested parties. And I agree with you, Anya, that the ruling Gibbs is divisive. Some people say that it is outdated and that it is against the doctrine of modified universalism and ignores international committee that is premised on respecting the decisions of foreign courts. Others say that the rule provides legal certainty for debtors and creditors, that the rule protects creditors against the risk of debtors filing for insolvency proceedings in a jurisdiction that might not respect the contractually agreed priority. In other words, it protects against any creative form of forum shopping. And it often applies in relation to creditors with English law governed claims arising out of English law governed contracts, who argue that their debts can only be validly discharged by a process in England. And creditors can take a different position and they may voluntarily submit to the insolvency or restructuring proceeding in France or Germany if they want to. But the key point here is that creditors are in the driving seat and they're protected by the Gibbs rule. And in defense of Gibbs, when you consider alternatives to the Gibbs rule, the starting point is the European Rome I regulation. And Rome I makes it clear that the governing law of a contract should determine how obligations under the same contract should be extinguished. And arguably, the position under Rome I is analogous to the effect of the rule in Gibbs.
Mm-hmm. Yeah, this can make us think about alternate routes, Christine. Do you have some suggestions, and such as initiating parallel proceedings to circumvent or mitigate the refusal to recognize the Part 26A proceedings in Germany? Do you have ideas on that?
Yeah, I mean, I think the safest way, what you just said, would be to initiate parallel proceedings. However, that goes along with the respective efforts and time and cost and yes, all that. What's been done before is that the applicable law had been changed from German law or other applicable laws to English law. Question is that possible in the respective case? But I think if that works, it is a good way. And then also ensure that the COMI is in the UK from German perspective, since Germany takes about a strict view on where COMI is. Yeah, and I think what I just said, like the Frankfurt decision is not the final decision. So there's going to come, an update is going to come, but it may take a year or two. So until then, we can work as a lawyer.
Yes. And when we have a look, now we have a look to the US and the recognition in the US of European restructuring plans under Chapter 15. Juliette, do you have to report an experience of challenges encountered by US French practitioner?
Well, one of the most recent and the most important in France was the Altis France case. Because Altis France is a major player in the telecommunication sector, notably known by SFR, the second French largest telecommunication operator in France. And historically, the group has financed its development through debts. And group financial indebtedness could be summarized with 3 points. The first is 2 revolving credit lines of 1.2 billion euros. The second one are 7 midterm loan of more than 7 billion. And the last one are 11 lines of bondholders for more than 11 billion. Listed on the Luxembourg Stock Exchange and TIEC. we had a lot of guarantees given with intercreditors agreements for all this scope and perimeter of debts, with personal guarantees, real estate securities, and parallel debts, especially for the security agents amongst the lenders having claims against Altice France and the guarantor subsidiaries, mirroring the claims held by the creditors party to these agreements, the intercreditors agreements. So the level of indebtedness was very high. They had to restructure to find some agreements and first negotiation with the identified creditors, and then workout agreements. So they decided by end of 2023 to work on a restructuring plan to reduce its indebtedness. And the negotiation with the group, between the group and the financial partners, resulted on the 25 February 2025 in signing two workout agreements. The first one between Altice France, Altice Holding, and the guarantor subsidiaries with some of the financial creditors for the midterm loans and bond issue. And the second was with the holding companies, mainly for bonds creditors claims. The second one was the easiest one to implement according to what was all the information provided are public information, of course, of that case. And what was evidence from practitioner on all the stakeholder involved in that case is that the easiest workout agreement to reach was the second was with the holding company. So even not in pre-insolvency scheme outside. But the second one, they needed to go through conciliation first to find some agreements. They reached partial agreements, but not all the agreements. And that's how it's complicated and it leads to the US perspective. Because since they did not have a mutual consensual agreement, because it's how it works, right? According to the EU regulation of pre-insolvency scheme. Under French law, you cannot impose. You can get some delay in pre-insolvency, but you cannot impose an agreement. So they had to reach the majority requirement of the intercreditor agreement to get the full success of this restructuring. Unfortunately, that was not the case. So they had to leave the conciliation process to run for an accelerated safeguards in order to force the agreements, because under French law, if you file for accelerated for safeguard, you automatically get a cross-class crime down application. You don't have to reach some thresholds. This is how they guarantee the success of this implementation of the workouts without a consensual and amicable process. And this is why when you get an accelerated safeguard, it's a public proceeding in France. So it has some effect in France, but not over the assets located abroad. So this is why if they wanted to stop any action from creditors having rights, being in position to activate securities, they had to reach a US recognition of what was implemented in France. So this is how, by judgment of 10 June 2025, the Paris Business Activity Courts, the new name of the commercial courts, opened accelerated safeguard proceeding for Altice France and other guarantors companies, subsidiaries. And regarding the cross-border application, Altice France and the guarantor subsidiary sought recognition of the effects of this French accelerated safeguard proceeding from the US courts on the basis of Chapter 15 of the Federal Bankruptcy Codes. So they seek the protection of the US courts for all the assets located in the United States. And the recognition of the foreign main proceeding by the US implied an automatic stay and certain other provision of the US bankruptcy codes that take effect in the US. But it's not the French law that is applicable. And these requests were subject to a first hearing before the Southern District of the New York Bankruptcy Court on the 18th of June 2025, giving a ruling very shortly 2 days after, on the 20th June. And the court issued a decision temporarily recognizing the effect of the French accelerated safeguards and setting a date for the hearing for a definitive recognition. And we got information from the newspapers that the definitive recognition took into force by end of July. So this is quite interesting because it reflects the practice of restructuring practitioner working with an holistic view of how to restructure and how to secure the right of each parties, even if you have to play outside your jurisdiction, and how to find the right tool dedicated to get, to get the success of your restructuring in a time constraint, but with all the guarantees for the success of the restructuring and not having creditors taking over the assets aboard.
And thank you very much, Juliette. And from the German side, do you have an example, Christine, when you went to the US?
Yes, I think to my knowledge, so far there's been one recognized direct case in the US under Chapter 15. It was the Spark case, where Jones Day was involved, but prior for me coming here. And the case is interesting in that regard that notably the debt governed in that proceeding was mainly US governed. It was US based directors, and two of the companies were listed on a US stock exchange. So it would have been more natural to bring it to a Chapter 11, which would have been much more expensive and a number of different issues. So we took a very US-lastic proceeding, put it into a German stock, and then got the recognition in the US. Maybe just it all happened in 2023. And maybe what is also interesting, there was the Spark Network SE as a European German company, and they started proceeding over the SE was recognized as main proceeding under Chapter 15. And then US Inks that had granted third-party releases through the direct proceeding. And those third-party releases were recognized as for non-main proceedings and thereby affecting an intra-group debt relief. And this is quite interesting because, as we all know from the Purdue case, the US is struggling more and more on how to grant third-party releases and what is possible and what is not possible. Because through the Starwork, we were able to do this third-party release and import it into the US through Chapter 15. And there comes the very friendly attitude of the US courts towards recognition of foreign proceedings, that they are quite willing, as long as certain rules are adhered to, in particular procedural rules, to recognize foreign proceedings, even if they have mechanisms incorporated that wouldn't necessarily be acceptable under a US proceeding. I think this is quite remarkable because in some complex cases, it may just be worth the consideration whether to look for a German proceeding or a French proceeding and combine it with maybe a Chapter 15 and thereby avoid cost and have some opportunities that wouldn't be there otherwise. Also, Anja, what we discussed beforehand might be an interesting case. You asked, what from a practical perspective were the key factors or the practical factors and getting
the
this recognized.
Somehow, yes.
Yeah, and I did call my US colleague that was heavily involved in that case and asked him what were the hurdles you came across and what was the important part so that the whole thing worked. And he said two things. First of all, you have from the beginning or as early as possible try to involve the local council as well as the US council, so that you don't do the start proceeding and then you call the US council and be like, no, we want a Chapter 15 recognition, but that you include the US council with the start of the start or French proceeding. And he said this is extremely important because what we did, we tried to let the start proceeding look like a Chapter 11 proceeding. So he said, in particular, there's a lot less information obligations under a start proceeding. It's a lot more secretive. It's a lot harder to get information. While in a Chapter 11, all the information is put out there, and there are even specific websites providing all the information. So he said what they did in that Spark Start proceeding, create a website on crawl. You can still find this website with all the information on it, providing all the detailed information as you would do in a Chapter 11 proceeding. And when approaching the US court, they could say, here, look at this, and thereby could show full transparency what they had done to include the creditors so that the creditors would be heard. So the main concerns coming from US courts, whether the creditors' rights have been given enough room and all that, could be shown that this was the case through using that webpage.
Very interesting indeed. One must notice, however, as for the third-party releases, I think it's important to say that I guess there were not class actions, and that's the big difference, of course, in the overall consideration. So now again, we are going back to the UK, Anna, in terms of a sort of forum shopping and thinking about the fossil case, which I found very interesting, where the US went to the UK looking for a restructuring plan. Instead of going to the US. So now they come back to Europe. So that's could you develop on this part and report a little bit about the UK plans, the last trends, why they are so attractive now, also for US
Yes,
editors.
exactly. So what Christine told us about Chapter 15 recognition of UK, of German proceedings, and also about that new Supreme Court case in the US, as Harrington versus Purdue, the same considerations apply in the UK. So you could have a restructuring plan done in the UK or a scheme of arrangement done in the UK, even if you are a US company, and then you could take benefit of non-consensual third-party releases and obtain Chapter 15 recognition of such releases and the whole restructuring in the US. And the same outcome would not be possible if it was just a Chapter 11 case where non-consensual third-party releases are not permissible. I also spoke to my US colleagues about it, and it's a topic that is very close to our hearts. It's very interesting because there's a lot of noise in the US about Chapter 11 becoming very, very expensive, and the UK in the fossil case, but there are also other cases, McDermott, it's also Syncrian. US companies actually decided to do restructurings in the UK. But responding to your second question about recent trends in the restructuring markets in the UK, it's such a big topic. I will try to only highlight the most interesting developments in the last 18 months, which is actually quite a lot, because historically in the UK, pretty much all schemes of arrangements were sanctioned. But in the last 18 months, we have 3 Court of Appeal cases. In 2 cases, the first instance High Court decision was actually overturned by the Court of Appeal. One is the Petrofac case, another is the Adler case. So it was a surprise for the company that proposed the plan. We also had a third Court of Appeal case in Thames Water. At this time, the restructuring plan and the decision of the first instance court was upheld. But to make the whole landscape even more interesting, now there is a Waldorf production restructuring plan where the High Court refused to sanction that plan, and permission was obtained to go straight to the court, to the Supreme Court. So there is an appeal to the Supreme Court which is pending. First time ever, it's likely that the Supreme Court will have to hear a case involving a restructuring plan. So what's happening in the UK is that there are more challenges because there is a cross-class cram-down feature, which is available under Chapter 11. And this means that you can impose the restructuring plan on a class that is not voting in favor, provided that at least one class, which is in the money, supports the restructuring plan. The court needs to exercise its discretion and feel that the whole restructuring plan is fair. But we had more challenges recently on various grounds. It could be because of valuation, but also now following the Petrofac case, there is some uncertainty as to when is the right time to engage in conversations with creditors that are out of the money, because they need to participate in the fair share of the restructuring surplus. There is also some uncertainty surrounding new money that is provided by restructuring plan creditors. What is the fair element of that new money? And is it necessary to obtain expert evidence confirming that the allocation of the interest rate on new money is fair, or perhaps there needs to be some sort of market testing? All these new considerations that were not present before the restructuring plans were implemented under English law are now very much live. And my view is that at some stage we'll obtain enough clarity that everyone will move on and we'll again have more restructuring plans, and we'll have more case law that will help us to better plan restructuring plans. But at the moment we are in that zone of, I would say, lack of clarity as to how to structure a restructuring plan in a very tight time frame. So the timeline may be extended. In fact, now we have a new practice statement for restructuring plans and schemes of arrangement that was recently published. And if cross-class cram-down is expected to be required, the plan company will need to provide evidence before the convening hearing as to their efforts to engage with creditors. So it's also an interesting development. And some creditors are thinking about doing restructurings differently. So it could be distressed disposals under the intercreditor agreement, or it could, and then a scheme of arrangement, or it could
Yeah,
be
actually a lot of new issues popping out,
yes,
and which will have to be developed.
Exactly. Or LMEs, yeah.
Yeah, or LMEs, of course, another big topic we will be addressing within another webinar. Let's come very briefly to continental Europe, including Ireland, of course, and the EU directive Insolvency III. Juliette, where is the status of the discussions? Could you just give us a brief update? We don't have a lot of time left.
Thank you very much, Anya. Regarding the EU Directive 3, so on the 7th of December 2023, the European Commission published a new draft directive, Insolvency 3, aimed to further harmonizing insolvency law between EU member states. With three main objectives. The first one, to maximize asset recovery in the event of liquidation. The second one, to ensure the efficiency of insolvency proceeding. And the last one, to guarantee a predictable and fair distribution of recovery value among the creditor. And so the idea is to maximize the recovery value for creditors. It's to propose and introduce a minimum set of harmonized conditions for avoidance action, what we call the nullity of observation period, suspect periods in France, to reinforce the asset tracking, and we will talk about it very briefly, to generalize pre-pack sale, and which already exists in France. But even though efficient is very time constrained and sometimes not very well known from other practitioners, so information not very fully disclosed. And the last one after pre-pack is to require director to promptly file for opening of insolvency proceedings, which already operate in France, because you will be under breach of duty, mismanagement action if you fail to declare an insolvency estate within 45 days. So the European Commission proposed also to introduce a simplified liquidation procedure for very small companies being insolvent, which is something that is very much debated and challenged in France, because the bankruptcy bodies, let's say, liquidators may not intervene, which is something that is not possible under French law right now. And to the second one, and that German is already something that inspired this EU directive, is to get more transparent information for creditors regarding the main feature of national insolvency legislation, i.e. the creditors committee, which is under French law what we call already the supervising creditors being appointed. They can be up to 5 to follow the proceedings. But just to get the timetable. So right now, we had the European Economic and Social Committee's opinion issued on the 22 March 2024. Of the same year, the opinion of the European Data Protection Supervisory and the Economic Monetary Affairs Committee of the European Parliament delivered on November 24, so over a year ago, all that opinions. And the Council of the European Union approved on December 24 a partial general approach, which means that member states reach a compromise under certain title of the proposal. This is what was already something we can move on, that required all the member states' approval. And there are 4 titles. So the first title is minimum harmonization rules concerning avoidance action, so nullity clawback actions. The second one, so we already referred, relates to asset tracing in cross-border insolvency in order to maximize the possibility to recover assets under your jurisdiction, but also others' jurisdiction, EU jurisdiction. And the third one relates to the director obligation, which I briefly recalled, with the obligation for a director to declare an insolvency estate. And the last one, the measure of reinforcing transparency in national insolvency laws. So discussions are still continuing. Under the French scope, we are still working on that. With nothing is yet finished, let's say. It's still ongoing. And but what French people and most practitioners commented is that this new directive will not implement substantial change under French law.
I don't agree.
Let's see.
So I think the aim is what I heard. Sorry to interrupt. What I heard is that it will be issued still this year, and
by end of year.
Very end of the year. We are very keen to read it, the final version.
If we talk more about this creditor committee, which will be something that is new in France, if it applies, the idea is to strengthen the role of creditors in the collective proceedings, and this creation is inspired by German law. And if Christine wants to give
Thank you very much.
a quick look after that. These committees, they are composed of 3 to 7 members. They can be set up either by decision of general meeting of creditors or before the opening of proceedings. At the request of one or more creditors that would be responsible for acting in the interest of the creditors. And I will not detail all the function, but the idea is to get some creditors being empowered to follow and get all the information or require and look at information not given already in order in the idea in the good conduct of the insolvency proceedings and the treatment of the collective treatment of the creditors. Regarding asset tracing, I just get the summary because I know we are running out of time. In order to improve the recovery of debtor assets, the draft directive improves regarding the means available to insolvency practitioner to trace assets belonging to insolvency estates. As such, the court should be able in the future to access information relating to the debtor bank accounts and conduct direct or immediate search, including in another member states, whenever necessary to identify or trace the debtor assets. To this end, the court may use what we call it the single access point to the centralized bank account registered, which was established due to the regulation regarding anti-money laundering. And if the debtor is a legal person, so a company, then you could have access as an insolvency practitioner to the information on beneficial owners in all member states. So these are the main, let's say, measures that this EU directive may implement shortly. And I want to be optimistic as Anya is by the end of year, but
This is what I heard. This is what I heard. So
the last EU transposition, we were not the best, let's say, students of the class for that. So let's see.
Thank you very much, Anna, Christine, and Juliette, for your participation. For the audience, if you have questions, please go ahead. Perhaps, Helen, we should raise the questions within the breakout sessions for those who are interested to join us for 20 more minutes.
Sure, the breakout rooms are all set up for you. Thank you so much to our panel today. Fantastic conversation, and please stay with us. There are no formal questions or direction when we send you to the breakout room, so please stay with us and use it as a meet and greet and a networking opportunity too. So I'm going to open up those rooms. Please look out for a little pop-up on your screen and accept the invite to join. We'll give you a 5-minute warning when you're getting close to the end time. Thank you once again for joining us today. Great to see you. Thank you.